Good afternoon, Lawrence. Welcome back to Twice Told.
Lovely to be with you again, Praveen.
It's such a pleasure to read the balance of your book, and I would strongly recommend that this book be nominated for this year's Pulitzers because of the kind of information that you've covered, the ground that you've covered, and the scope of it. It's amazing. This will remain an extremely important book for generations to come, pointing a solid finger straight in our faces. What were you doing when human rights were being violated across the world?
Well, thank you so much for that incredibly kind endorsement.
The pleasure is all mine, Lawrence. So I'm going to start off with my first question about the Little Treaty of Versailles. Could you tell us a bit about this? Who or what is the definition of a powerful nation that gets to define such one-sided treaties, and upon whom are these treaties enforced or exercised?
Right, so Little Versailles was technically had the name of the Polish Minority Treaty. It was actually signed on the very same day as the Big Versailles Treaty with Germany. I think that was on June 28th, 1919. And um, and what the treaty did is, I guess we need to bear in mind that if you looked at the map of Europe after World War One and looked at it prior to World War One, it looked very, very different because suddenly you have the unraveling or the collapse of these major European empires. We can leave aside the Ottoman Empire, but it's the end of the Austro-Hungarian Empire, the end of the Russian Empire, end of the German Empire. So suddenly you have these new states that are being created. And what the kind of powerful victorious states um, in World War One did is they basically conditioned the recognition of these new states on their willingness to protect their minority populations. And in the case of the Little Versailles Treaty, the country that was being recognized and in international law was Poland. And the stipulation was that Poland had to then protect its a number of minority populations, its Jewish minority population, also its German minority population, because there are many ethnic Germans who are now absorbed into the new borders of the state of Poland. Now, the thing that made the whole thing very controversial is that the victorious powers, countries like France and Britain, they didn't have to subscribe to any kind of international agreement as to how they were going to treat their own minority populations. The United States didn't have to sign on to any kind of agreement about how it would treat its own minority populations. And in fact, even Germany, which was the main defeated nation in World War One, in the major Versailles Treaty, there was no stipulation that Germany had to agree to proper treatment of its minority populations. And so it created these treaties, and it wasn't just treaties that were made with Poland. There were also similar treaties made with these other new states in Europe, like Czechoslovakia and Yugoslavia. And they all had slightly different stipulations, but they all conditioned recognition on the proper treatment of the minorities. And that created a lot of hostility because it was basically saying you're treating us like secondhand citizens, secondhand states, that you, the big guys, don't have to treat your minorities well, but you're kind of insisting that we do so. So it did create this kind of lingering resentments about almost these kind of dual understandings of sovereignty, the sovereignty of the great powers and the sovereignty of the lesser states.
Understood. What was the background for this, and why did these powerful states enforce these rules on the lesser states? What did this have to do with the balance of power or retaining some form of status quo?
Well, I mean, I think that, there was a kind of, we might say, a positive humanitarian impulse behind the creation of, let's say, the Polish Minority Treaty. At the end of World War. One, of the Great War, you did see a number of atrocities taking place in the territory that became recognized as the independent Polish state. You had these kind of pretty vicious pogroms that were directed against the Jewish population of Poland. So there was a kind of feeling that it was important to protect these minority populations. More generally, you can also say that there was a pretty widespread understanding that the way to avoid future international conflict, and I think that was really more the concern. The concern wasn't so much about humanitarian impulse. It was like, how do we avoid future wars? And the way to avoid future wars is to make sure that, let's say, ethnic Germans in Poland aren't being mistreated by the Polish government, because if they are, then Germany is going to intervene and then we're going to have another war. And so I think the main impulse was try to protect these minorities as a way of protecting and promoting international peace. And in fact, some of the most radical proposals, it wasn't just proposals, some of these things were actually acted on, was, the best way to do that is just create these ethno-national states. One of the things you see after World War One is basically the unwinding of the populations of Greece and Turkey. That you had many, many ethnic Greeks living in Turkish territories, and you had many, many ethnic Turks living in Greek territories. And what you have this kind of compulsory unwinding of the population, and that again was supposed to be in the interests of promoting peace.
Understood. Now, moving on with the first recorded instance of a genocide during World War One, the Turkish genocide of Ottoman Armenians, and Soghman Tehlirian, the Armenian who attempted to assassinate Talat Pasha in Berlin. Now, how is it that Berlin offered refuge to Talat Pasha, knowing that he and his cabinet had enabled and executed a war crime? And secondly, why this disparaging statement against the Ottoman Empire that they are barbaric and semi-human, therefore human rights need not apply here?
Well, first of all, we should notice that Tellurian, it wasn't an attempted assassination, recall. It was a successful assassination. I mean, he did shoot down uh, Talat Pasha on a street in Charlottenburg in Berlin, and then he was tried. More generally, I thought, remember that Germany and the Ottomans during the war were allies. And even with the kind of the change of the German government at the end of World War One, there was still kind of sympathetic feelings towards the former Ottoman leaders, and so that was the way they were able to be, or some of them were able to take up residence in a posh neighborhood in Berlin. What, of course, is interesting is that there would have been no trial whatsoever of the idea of trying a former Ottoman leader in Germany for atrocities committed against his own domestic population would have been unthinkable. Unthinkable, first of all, for political reasons, and then second of all, again, this is where we see this kind of absence of the necessary international criminal law in place at the time because, obviously the former Ottoman leader, he was not a German subject. The victims hadn't been German, and the crime scene hadn't been Germany. And so basically, at that time of place, Germany would have had no jurisdiction. And so you have instead this kind of very interesting vigilante trial of the assassin. And the assassin, actually, this Tellurian, he basically presents himself as a sword of justice, as basically providing the kind of legal response that a German court or any other court, for that matter, would have been incapable at the time of offering. And the thing that is interesting is that he's actually acquitted. The jury spends very little time deliberating and acquits him. And even though he was on trial for murder, the Ottoman leader, Talat Pasha, basically ends up having the prosecution of the murderer of the assassin ends up basically being put on the defensive, trying to defend the the murdered Ottoman leader for having basically orchestrated these mass atrocities against Armenians uh, in the Ottoman Empire.
Understood. But why this label that the Ottoman Empire is semi-barbaric and therefore human rights don't apply?
Well, it wasn't so much that human rights didn't apply at all, but the thing that's so bizarre in the trial, Praveen, is that the prosecutor who's trying to get the assassin convicted, he's the one who basically tries to downplay the atrocities against the Armenians in the Ottoman Empire by saying, "Hey, let's remember this is only a civilized place. A lot of savage, awful things go on there. So let's not use our German standards of what's civilized in trying to evaluate the conduct of the Ottoman leaders at the time." So it is this kind of incredible irony that it's the prosecutor who's actually introducing all this language about semi-savagery and barbaric practices for the purposes of trying to play down the magnitude of these mass atrocities that have been committed against the Armenian population. And, I think even at the end, towards the end of our last conversation, I think we had an opportunity to see that that really was not an idiosyncratic position on the part of this prosecutor, that basically many prominent jurists in the West at the time similarly had this kind of picture of the Ottoman Empire as, only kind of semi-sovereign and semi-savage.
Understood. Now, I cannot scarcely imagine a courtroom today if this argument were to be made by the prosecution. I believe that the prosecuting lawyer would likely lose their job and not only be now tarred for life for making such disparaging comments, and especially this against your own former ally who had fought alongside you in war, and then you are tarring them with such negative remarks.
Yeah, no, it is. It's obviously deeply ironic, though, of course, the prosecutor's just trying, I suppose, to win the case. And suddenly he does realize that the victim, in a sense, the victim has become the perpetrator in the trial. So I guess he's trying to, in a sense, turn the direction back on Tellurian's activities and away from those of the former Ottoman leader.
Understood. Now, assuming that the Ottoman Empire had been a European entity or was on par with European modernity and standards, would this argument even be possible? And assuming that the Ottoman Empire had committed the same atrocities, the Armenian genocide, as a European entity, how would it have been processed or executed?
I mean, that's a very good question. I mean, it's a very good question because, is it possible, for example, that we would have already seen a Nuremberg-like tribunal constituted, back in the time? I mean, obviously, it's hard to play history by counterfactual, but it's certainly, worth entertaining. On the other hand, you can really ask yourself if, let's say, Germany had simply, I'm talking about now Nazi Germany, if Nazi Germany had simply directed all of its atrocities domestically and not and hadn't, let's say, also waged this war of aggression in which it committed atrocities on basically the lion's share of its atrocities were committed on the soil of other nations, whether you would have actually had a Nuremberg trial. Would you have had a Nuremberg if German atrocities had been localized to their own population? And clearly you find other examples in which there's no call for real international trials uh, in response to colonial outrages. So you obviously have atrocities that Germany committed against the Ovaherero people um, in what is now today Namibia. but at the time, there was no call for any kind of, legal international reckoning with that kind of behavior. It was basically, the excesses of colonial administration. And likewise, you didn't find any calls for the trial of King Leopold in response to the astonishing atrocities that took place in the Congo under his administration.
Understood. The period between 1940 until perhaps 1980 might have been quite jarring for so many European countries now that they are faced with the prospect of decolonization, coming to terms with the scale of crimes and atrocities that they've committed, and when prosecuting other fellow nations, as we'll be discussing about Japan, about their crimes of aggression. And their answer was, we are merely following or mimicking the European model of expansion. So, why is it that when we commit this crime, it is dubbed a crime, and when you did it, it was perfectly acceptable conquest?
Yeah, so now we're kind of jumping ahead a bit, and this is now the kind of companion trial to Nuremberg that takes place in Tokyo. This is the so-called International Military Tribunal for the Far East that takes place basically from about 1946, April 1946 to November 48. And this is a trial of 28 leading Japanese functionaries. And in a certain regard, it is meant to build on the precedent of the Nuremberg trial. That is the main charge against the Japanese on trial, is that they committed crimes against peace, that they waged a war of aggression. And as an ancillary matter, they're also charged with war crimes as well. But again, the main charge is crimes against peace. The thing that's a little bit different about this is even though it is meant to build on the Nuremberg precedent, that is to basically solidify this notion that crimes against peace is what we might say, the paradigmatic crime in international law, it actually ends up weakening the Nuremberg precedent. And it does so because of the dissents of two of the judges at the Tokyo trial. One of the judges from Netherlands, this Bert Groening, he basically kind of acts as if Nuremberg never happened and says, what is a crime against peace? We've never recognized that as a crime in international law. I don't even really think of it as a crime. In fact, he goes back to the Napoleonic precedent and says, yeah, I can understand why we might want to take these people out of power and make sure they don't exercise power again. But we shouldn't act as if crime against peace is really a fully established crime in international law. And then you have the justice from India, Paul, who really engages in this 700-page, incredibly detailed dissent, in which he argues, as opposed to Ruling is basically arguing, when did this become a crime? Paul, by contrast, is really makes a normative argument, saying that, wait a second, the world has been carved up by Western aggression for centuries, committing war, as we noted in our last conversation. Going to war was understood as a prerogative of Western sovereign states. And now, suddenly, after carving up the world through their aggression, these Western states now get together and declare aggression an international crime. In fact, the most basic and fundamental of international crimes. And so he basically kind of accuses them of kind of engaging in, transparent hypocrisy. And he has, a number of these very kind of powerful lines where like, sure, after you've lopped off someone's head, you're very happy to put your sword back into its sheath. And and so it's a very powerful dissent, and it's a dissent that certainly resonates very powerfully in post-war Japan.
Absolutely. The hypocrisy is absolutely stunning in its scope, especially when Justice Rowling speaks about crimes committed as masterpieces of art. How can someone possibly speak like this in a courtroom, that is?
Yes, well, idea was that I'm not sure that was Rowling who actually made that statement. Um, I believe it was the. Well, anyway, let's leave that to the side. It was basically trying to argue that I think one of the judges or lawyers were trying to argue that. But we have to understand that that war making is like a cultural form. And you actually have many people have argued something similarly over the time. There are people who have been very much defended war making as a way not simply of advancing your political interests, like Clausewitz insisted, but argued that it's actually a form of establishing a deep meaning among a people and creating, a helpful way of creating cultural cohesion. Um, it is a little bit of a somewhat shocking thing to say in this context, and but I think you're absolutely right to kind of point out um, that there really were these very clear vulnerabilities in this effort to make aggression the centerpiece of this post-war system of international criminal law, given the fact that so much of the world had been basically carved up through aggression that was protected through basically generations of recognizing sovereign prerogative.
Understood. Now, I'd like to come back to the Nuremberg trials and post-war Germany. I don't remember if we spoke about this in our previous conversation about the Nazi government being run on Hitler's personal directive, an argument made about it as not so much as a state authorized by law and legislature. So, keeping this in mind, why were Nazi judges who passed and authorized Hitler's decrees, why were they still maintained and pressed back into service? Rather, if the Allied powers had deputed some of their own judges for an interim period of, say, 10 or 20 years, train non-Nazi or denazified judges and jury in development lawyers and ensure that these tainted judges never come back into the picture because they ultimately helped authorize what was the criminal or rogue state.
Yes, well, it's certainly a very fraught question that you're bringing up, and recall that there were that in one of the subsequent Nuremberg trials that was staged by the U.S. military, there were the so-called justice trial, and these are 18 former jurists and lawyers of the Third Reich who were prosecuted, and most of them were convicted by the U.S. military in this trial. The other question that you're bringing up, which is also an incredibly important one, is the composition of the reconstituted German judiciary after the end of the war. And excuse me. And yeah, I think one of the things we need to, obviously the Allies, they wanted to create a stable democratic state that was dedicated to upholding the rule of law. At the same time, they didn't necessarily want to buy into a project of a generational long occupation, during which time they would have to basically train an entire new generation of German jurists. And we can understand their reluctance to do so. I mean, obviously, it would be very expensive, and obviously, it could also incite the resentment of the German population, who also, notwithstanding their astonishing crimes that their past regime had perpetrated in their name, were nevertheless eager to reestablish their own sovereignty. And so, there was a 5-year period during which, really focusing now in West Germany, in which you have this kind of occupied, this Allied occupation, during which there's a concerted effort to reconstitute the German judiciary. And yet the Allies quickly find out that it's hard to find untainted people to serve in positions of leadership within the reconstituted legal system. They're able to kind of bring back certain judges and jurists who had fled during the war, who had been persecuted by the Nazis, but there just weren't enough of them. And so they end up in basically kind of looking the other way and rehabilitating some people who were deeply tainted, deeply tainted. And by that, I mean, you have people in the very highest courts in Germany who formerly served under the Third Reich. And, within the state of Bavaria, the largest state of Germany, you have 80% of the judges in the 1950s were former members who were judges under the Third Reich. And so, yeah, very kind of problematic legacy.
The p- I understand that this was a problematic legacy to begin with, but I was also thinking about it from the longer point of view. Now, if you compare and contrast it with the United States following the Civil War, and when the defeated Confederate elites were let off lightly, what then happens is that these people carry those resentment and those feelings they then get transmitted to the next generation, and they wait for a time when they could possibly make a comeback in another form, in another way, or another political movement. So if the Allied powers had done something to the extent that fascism, or at least in this form, by prosecuting the judiciary, the people who authorized this, more so than the leadership of the military who perpetrated the war crimes, this may have set a very different precedent for future far-right governments in the world.
Yeah, I mean, it's one of these, fascinating questions. There's a whole field, of transitional justice, which deals with the very question of what is the most efficacious and what is the wisest and what is the most just way of reckoning with a past um, a regime, basically a criminal regime or criminal state, and is the best way to engage in some kind of ambitious prosecutorial campaign, or is the best way, for example, the South African model avoided very much a prosecutorial campaign and arrived at this device called the Truth and Reconciliation Commission, which has gotten some very good publicity. On the other hand, a lot of people have argued that it failed to establish truth and it failed actually to really lead to any kind of meaningful reconciliation. The one thing it might have done is it might have avoided civil war, which is again something that is nothing to be sneezed at. So it is a really important question, this question of how do you deal with the crimes of the prior regime? And just to kind of emphasize the point that you're making is I think in our last conversation we did discuss the somewhat disappointing, not somewhat, actually quite disappointing record on the part of the German, by this I mean the Federal Republic, what was then West Germany, of its legal system to deal with the legacy of not of domestic of you of people who had served in the Nazi regime. I mean, obviously, they did do a number of prosecutions. There were several hundreds of people who were convicted, but that's not a particularly robust number. But I believe that the number is around 600 people who have been convicted of Nazi-era crimes. Of the 600 that were convicted in Germany, not a single one was a member of the judicial apparatus. Zero. They never had a successful prosecution of a former judge who was basically, in a sense, a hangman of the Third Reich.
Understood. Now, speaking about the non-military trials at Nuremberg, who else were put on trial apart from the judges and lawyers from Nazi Germany?
So in these follow-up trials, the subsequent trials, these 12 trials that were organized by the United States, in which about 185 former Nazi functionaries and accessories to the state were tried. You have industrialists put on trial. You have members of the SS who participated in the so-called Einsatz Gruppen, which are these kind of mobile extermination units that combed the countryside and basically took the overwhelming number of them were Jewish civilians who were taken out and just shot in these open air pits. And they also tried doctors. There was a trial of members of the medical establishment who had participated in human experimentation. Um, and you also have bureaucrats who basically were, sitting behind desks and organizing acts of atrocity.
Understood. So ideally, Adolf Eichmann should have been prosecuted under the non-military trials at Nuremberg, though he escaped, right?
Yeah. I mean, the one thing I understand what you mean by non-military because they weren't just generals who were being put on trials. Technically speaking, we might want to avoid that term only because it was still called the American trial program was called the Nuremberg Military Tribunals, only because they were under the auspices of the U.S. military. But your point's well taken that the people on trial were not exclusively members of the German military leadership.
Understood. So what might be a better way to describe this trial, which did not focus on members of the German military?
So are we talking now about the Eichmann trial or? Yes. So the Eichmann trial, remember, this is not a trial that is conducted by the US military. This is a trial that takes place in Jerusalem in 1961. And Eichmann is, he would not have been a defendant at the first Nuremberg trial because I don't think we would say that he was really a member of the Nazi elite. We could say he was kind of a mid-level bureaucrat, but his position was very important because he basically was the chief logistical officer responsible for the deportation of over 1 million Jewish people to killing centers in the East. And um, and again, this was not at all a war crimes trial. This is really a trial about atrocities committed against the civilian population. And it was very consciously organized as a trial that was meant to highlight the atrocities that had been committed specifically against the Jewish population of Europe.
Understood. Just before the Eichmann trial, is it right that the Genocide Convention had been agreed upon and finalized?
Yeah, so the Genocide Convention had already been, so remember, genocide was only coined as a term in 1944, but it was always already recognized as a freestanding international crime with the passage of the Genocide Convention by the UN in 1948. In fact, the Genocide Convention is the very first convention that's framed by the fledgling UN. And so that happens in 1948. As a technical matter, the Genocide Convention really comes into effect in 1951 when a sufficient number of state parties ratified the instrument. But yes, that's correct.
Understood. Now, returning to the Eichmann trials, do you believe that if this trial was prosecuted as crimes against humanity instead of the specific argument that these were crimes against the Jewish people, might this have set a bigger and broader precedent for future acts of genocide?
So that certainly is an argument that was made by Hannah Arendt in her famous book Eichmann in Jerusalem. She basically said, um, the main indictment against Eichmann, the main charge brought against him was that he had committed these crimes against the Jewish people. And she argues, and I think it's not a trivial argument at all. She argues, what's a crime against the Jewish people? There's no such thing as a crime against black people. There's no such thing as a crime against Asian people. I mean, it's a crime against people. It's a crime against humanity. Um, you know, if you actually look at the definition of crimes against the Jewish people, it's she kind of overlooks the fact that it really does track pretty closely to the definition of genocide. And there are only some, kind of technical legal reasons why I think the prosecution in Israel used this crimes against the Jewish people as opposed to the genocide statute as the charging instrument. But yeah, I think for optics' sake, it would have been, I think, better. I think it would have created a more durable precedent to have simply charged them with genocide and crimes against humanity rather than using the somewhat more specialized charging instrument of crimes against the Jewish people.
Absolutely right. The perfect word is optics. That sure is the state of Israel prosecuted Eichmann under this statute of crimes against the Jewish people. It did good for the state of Israel that they are following up on justice is due. But if this was prosecuted more as crimes against humanity, this might have gone on to become a statute that could later be referred to not just broadly, but specifically applied directly onto future acts of genocide as well.
Yes, I think that's very well put. And in fact, if you, take any kind of course on international criminal law, the Eichmann trial doesn't play much of a role in such courses. And I think it's precisely because it was understood that it relied on a charging instrument that really is not recognized as a crime in international law. Whereas if it had relied on, let's say, genocide and crimes against humanity, I think it would have been seen as a much stronger and more durable precedent in the effort to kind of create accountability, legal, criminal accountability for acts of genocide.
Understood. Now, speaking about Hannah Arendt's book, The Banality of Evil, now that we know so much about how states create this atmosphere of distrust and eventually leading toward dehumanization of entire populations, how is it that we still don't have legal instruments that could be put into place or triggered whenever an instance like this happens in a foreign country, even though that country may not be declaring war, but we have the power of sanctions and global censure that we could wrap them on the knuckles for doing something such as this. Why is it that we still don't have legal artifacts or instruments which could be called in when a state is not not quite at the last step of performing an absolute genocide, but is starting to work toward one?
Yeah, it's a very good question, and I think unfortunately it also kind of piggybacks on our discussion, on our earlier discussion. Um, I think a lot of it has to do with kind of these continuing obsession on the part of states with protecting their sovereignty. This notion that states are very reluctant to embrace any kind of practice which could be understood to authorize any check on their sovereignty. So it goes back to this notion of what we described as the internal prerogative of sovereignty, that as a state, I get to treat my own legal subjects in the way I want. Now, does international criminal law today or the international community say that I get to engage in acts of genocide against my own legal subjects? No. The answer there is no. But then the question arises that you so well frame, which is, well, what do we do about that? What do we do in, let's say the run up to genocide, which can be very tricky? We can understand why we might not want to engage in any type of um, let's say, a preemptive attempt to stop a genocide that we think is going to happen, because that creates all sorts of opportunities for pretextual interventions into the affairs of states. I mean, it's no accident that we have Vladimir Putin saying that the reason that he invaded Ukraine was to prevent a potential act of genocide against ethnic Russians in Ukrainian territory. And then when it comes to something like actual genocide, if it looks like a genocide is actually unfolding, well, then you need to respond exceptionally quickly. And even then, it's not really clear, if you're going to have the international will to intervene. Actually, by the terms of the UN Charter, which more than anything is not designed to protect a minority population. It's really designed to protect international peace. In order to have any kind of military intervention into the internal affairs of a state, it needs to be ratified by the UN Security Council. And recall the UN Security Council is this device, this post-war device that creates these P5, these permanent five nations, France, Britain, United States, China, and Russia, each of which has an absolute veto power over any resolution before the Security Council. And given the kind of, global relations between the United States, China, and Russia, it's so easy to imagine that any kind of attempt to intervene or any type attempt to authorize an intervention will be simply struck down, vetoed by one of these P5 members, which then raises the question as to whether other states should be bound by it. And if other states aren't bound by it, if they go ahead and intervene to stop atrocities, are they actually in violation of the UN Charter, even if they're acting in a humanitarian interest? So these questions, Praveen, become incredibly fraught and difficult.
Absolutely. My next question leading up on that is about the International Commission on Intervention and State Sovereignty and their method of dispensing justice. Now, when we look at states such as Libya or Afghanistan, when these we know that these states were governed by despots, and that led to military action against them to depose these leaders. But what followed in its wake was we could never reestablish a political status quo which resembled something like a functioning government, especially with Afghanistan, Libya, and also Iraq. So where do we draw a fine line or a middle ground where in instances such as these we ensure that there are healthy functioning democracies without having to destabilize or completely throw that country off the rails?
Yeah. Well, if you and I could collaborate and come up with a plan for that, I think we'd be extremely successful people. And there might be many governments around the world who would be seeking our advice. Because obviously, this whole thing that we call regime change is, wow, what a mess that is. And, as you point out, I mean, there is, if you take something like Libya under Gaddafi, obviously a despotic ruler who was engaged in atrocities against his own people. And then you have this actually UN having this kind of the UN agreeing that there needed to be some kind of international response to stop Gaddafi from terrorizing his or from using violence against his own people. They relied on this doctrine of responsibility to protect. That is, that a sovereign state does not have any kind of right to engage in atrocities against its own. And at the same time that they authorized this kind of military response, they certainly did not authorize troops on the ground because that raises this whole, fraud issue about occupation. So people don't like occupation. And so what happens? Did the military intervention successfully take Gaddafi out of power? Yeah, it did. I mean, he ended up being, violently killed uh, um, by rebel groups. And what resulted in the wake of the collapse of the Gaddafi regime? Well, then you have this kind of completely failed state and the rise of warlords and a state which to this day is kind of just riven by domestic violence and basically this vacuum of power. So, how to create a stable democratic order in the wake of the deposing of what we might say is a despotic regime. I mean, we can look at Iraq, we can look at Afghanistan, we look at the US effort, 20 years and trillions of dollars spent, and Taliban is back in power in Afghanistan. And yeah, it's an incredibly, incredibly difficult problem.
Absolutely. I mean, with regard to a consulting firm, I believe the idea should all be yours because your book is forcing me to ask such questions. And if a layperson could ask such questions, perhaps an international jurist could go far better, form a
Mhm.
committee, and then institute a set of interim or transitional rules for how to govern a, a transition such as this from a full-blown autocracy into slowly defanging it without having to blow up the whole structure and result in chaos and have a more peaceful transition. Not just that, and also perhaps stop the permanent UN members from exercising the veto power for political considerations or clout. That when there are humanitarian concerns involved, you cannot possibly invoke the veto just because this is suiting your ideological position or your political power.
Absolutely. And that's very well put. And I do think that there would be, constructive first step probably would be to redraft the terms of the UN Security Council. I mean, even these P5, the idea that certain very powerful and important states, India, Brazil, I mean, they're not P5 nations, and this idea that France and Britain are, I mean, it's obviously a contrivance of a direct of the order directly following the end of World War II. So, and then in terms of like, trying to create this kind of transition from autocracy to democracy, I think we also just need to recognize that even some of our contemporary democracies might need to rethink how they're going to reestablish a more vibrant democracy. I mean, we've seen a kind of sort of dangerous erosion in democratic norms and the commitment to democratic governance in areas that we might have said were the most stable democracies in the world. So these lessons need to be applied domestically, not just in far-flung autocratic or despotic states.
Absolutely, absolutely agreed. Now, I'm going to return back to the Nuremberg trial and that disparaging comment once again, this time about citadel of boredom
Hmm.
for prosecuting an evidence-based trial. How could someone make an argument like this and possibly be present at that court without getting dismissed?
Well, the Citadel of Borden comment, that was written by Rebecca West. Rebecca West was a very prominent journalist who was covering the trial. Actually, while she was covering the trial, she also had an affair with the main American judge, Francis Biddle. But that's a little bit of extracurricular activities. But the reason that she described Nuremberg as a citadel of boredom is, I think, one of the things that we expect from the law, especially with these kind of spectacular, war crimes trials. Remember, Nuremberg was the first international criminal trial in human history. I think people expected high courtroom drama. We expect something like some Hollywood spectacle of drama. And in fact, it is true that a lot of Nuremberg was pretty boring. And part of the reason it was boring um, was because um, the prosecution chose to structure its case around captured Nazi documents. And the prosecution thought that, if we put eyewitnesses on the stand, people can always be trashed in cross-examination. People could argue that they've got that they're trying to settle political scores or that they have experiencing some kind of trauma and that they're just exaggerating things. Whereas if you rely on documents, well, those are kind of particularly captured documents, the authenticity of which can't be challenged. Well, that's a very stable way to build a trial. But it is the case then that if you are relying on a trial like that, the prosecution basically had to read the documents into the record. And that, as you can imagine, that can be pretty boring. And the other thing is they had to read them pretty slowly because at Nuremberg, you had this kind of ingenious simultaneous translation device that IBM had developed. And if you even see pictures from Nuremberg at the time, you'll see a lot of people wearing headphones because the trial was being simultaneously conducted in French, Russian, German, and English. And if you're engaging in simultaneous interpretation, the speaker has to speak pretty slowly. And so the idea of, an entire trial taking place in which someone is kind of slowly reading documents into the record, I think we can sympathize with Rebecca West's boredom. And if you think that Rebecca West was idiosyncratic, the judge that she was having the affair with, this Francis Biddle, former Attorney General of the United States, he also agreed. He also said, like, oh my God, this is like chalk being pulled across the chalkboard some of these days. So,
I completely understand where they're coming from, but an evidence-based argument is so much more solid. As you said, witnesses can be trashed, their testimonies can be fabricated, they can be coerced outside of courtrooms. There there's so much scope for manipulation, whereas with an evidence-based trial, you also get to uncover so many other lesser known players and actors, which otherwise we missed that opportunity to prosecute them. We merely went for the big fish, but the big fish are nothing but rubber stamps, whereas the smaller and mid-sized fish, those are the real actors, the bureaucrats, the the officers, the lawyers, the clerks, these are the people who facilitate this act of genocide. Those were the ones who might have possibly escaped scot-free, if we think about it.
yeah, and I think your point is well taken. And sometimes trials are not necessarily they're not there for the journalists. They're not there to create Hollywood spectacles. They're there to adjudicate guilt and to do it in a fair fashion. And I think one of the things in the years after Nuremberg, Nuremberg was really praised for having created such a vast archive of documents that create, in fact, many of the histories of the early histories written about the Third Reich after the war, they relied heavily on the archives that Nuremberg had assembled. And so the trial by document, it might have disappointed our desires for spectacle, but it certainly, I think, strengthened the legal profile of the case and also established this kind of evidentiary bedrock that historians then heavily relied on in the years thereafter.
Absolutely, absolutely. I found your book to be a solid critique of the present justice system, and that's how these questions came about. Now, have you had a chance to parse this book through international jurists and people in who pursue law as a profession?
I've done some talks with, yes, with international jurists. And so, yeah, so I have done some talks. I have a whole bunch more coming up for when the semester starts in the fall. But yeah, largely through podcasts such as your own, I've had conversations with international jurists. Yes.
And what were their thoughts on perhaps redrafting these international laws in light of your book?
Well, I think in general they've been, I think they've liked the book. I think I'd like to think that they like the book. I like to think they've been impressed by its scope and ambition. I think some of them have really disagreed with my understanding of the crime of aggression. I mean, I've tried to argue that really the focus of international criminal law should be on these atrocity crimes, on genocide, crimes against humanity, and that the whole effort of Nuremberg's effort to create crimes against peace or the crime of aggression as the centerpiece of international criminal law, not only did that fail, but I try to argue probably should fail. It probably was not the right way to devote efforts, as well-intentioned as that effort was. And I think a lot of people kind of they don't like that per se. There are a lot of people who are very committed to this notion of continuing to make um, the crime of aggression, the centerpiece of international law. And they don't like this idea that I argue that it should only be prosecuted if the aggressive war is waged in a manner in which war crimes or genocide or crimes against humanity are also committed.
Understood. It would do good for them to read Justice Radha Binod Pal's 700-page critique before they critique your stance on this.
Precisely, yes. I would encourage them to do so as well.
My last question is going to be somewhat philosophical. Uh, Do you think we could possibly imagine a form of progress in which wars of aggression and perhaps even genocide become entirely non-existent? We could figure out some way to now live more peacefully?
Wow. I mean, it's a lovely question. And the thing that is so interesting is we could even ask ourselves, has any country successfully functioned as a truly multi-ethnic democracy? I mean, you have had democracies function as almost, this homogeneous or almost kind of ethno-national states. You've had democracies obviously function that are multi-ethnic, that have been based on the suppression of the ethnic minorities. Have we ever really had a fully successful state that has been completely multi-ethnic and this function as democracy? You've had empires actually function pretty well as multi-ethnic empires, but it's a continuing challenge. And I think a lot of people have said, and we can think, wasn't that long ago that, let's say, Barack Obama was president of the United States, and people were saying this is a step towards, this is not the achievement of a true multi-ethnic democracy in which basic minority groups are largely treated equally, but as a step in that direction. And now we see how dramatically the United States has retreated from that commitment. So I think that will be one of the kind of the great challenges that we'll see in the years to come. And the other huge question, this goes back to this kind of basic question about sovereignty that we spoke about in our last conversation, Paveen, is the question about what's the moral significance of a border? Right now, people are treating borders as very, very morally significant. And, the way in which politics in so many states um, are organized around maintaining the integrity of borders and preventing, immigration. That itself, I think, is a very frightening and an issue that needs to be kind of that will continue to, I think, haunt our politics for years to come. So, maybe the most general answer to your question is a line that I like to repeat, which is, and I don't remember exactly who this comes from. It might have been actually from the old, might have been from Antonio Gramsci of all people, but it's a line that said, pessimism is an article of the intellect. Optimism is a feature of the will. So I like to kind of remain optimistic, even if my intellectual understandings of things may be pushed in a somewhat pessimistic direction.
I agree. I would like to read a philosophical essay or perhaps a book from you on what is the moral value or consequence of a border,
Mhm.
combining the legal research that you have brought into this book. That would be a fantastic treatise. I think so.
Yes, well, maybe that will be in the next book, probably.
Fingers crossed. I look forward to
Yeah,
reading more books from you,
yeah,
Lawrence.
yeah, lovely.
Thanks again for this. Thanks for making time for this conversation as well.
Absolutely. And thanks for the terrific questions. Really enjoyed it.
Likewise. Have a great day. Thank you.
Take care.
Take care.